the other side are really taken back by some of the arguments on Citizens United and some of the other cases. I'd just like to kind of set the record straight on some of those. Democrats' efforts to paint the Roberts Court as conservative activist court, I think those efforts fall short of even the most basic factual scrutiny. The rulings in question were firmly grounded in the law, the Constitution, and relevant precedent. And in fact, some of the so-called examples of, quote, conservative activist, unquote, opinions pointed to by Democrats were joined by some of the most liberal members of the court. And in the most off-sided case, Citizens United, the ACLU sided with the conservatives on the court. Take the Exxon Shipping Company versus Baker case. This decision was written by none other than Justice David Souter. Nina Totenberg of National Public Radio called David, quote, a full-fledged member of the court's unabashedly liberal caucus, unquote. In that case, the court merely held that under maritime law, which we all know is largely judge-made, punitive damages could not exceed actual damages of $1 billion. You know, I see a lot of beating the breasts on these things. Let's just take the Citizens United case. It's an important case versus the Federal Election Commission. Of the cases usually cited in Democrat critiques of the court, this is the only one in which the court actually struck down an act of Congress. It did so for a simple reason. The law passed by Congress violated fundamental law, the First Amendment of the United States of America, the United States Constitution, excuse me. The law in question prohibited the broadcast of political speech critical of politicians in the run-up to an election. In defending the law, I might add, Solicitor General Kagan and her office argued that the government had the authority to prevent the publication of movies and other forms of political speech, such as even books or pamphlets, although General Kagan did limit her critique to pamphlets at the time. Those movies, books, or pamphlets that advocated for or against candidates. Even the liberal American Civil Liberties Union filed a brief arguing that the law was facially unconstitutional and a poorly conceived effort to restrict political speech that should be struck down. Now, faced with a law through which Congress exceeded its authority, the courts applied the Constitution and struck down the law. The majority's opinion in Citizens United was not an act of judicial activism, it was an act of correction, overruling a 20-year-old case erroneously decided by 5 justices who clearly substituted their policy views on how elections should be conducted to the dictates of the First Amendment. Now, the court simply returned the doctrine it espoused in the 1976 case of Buckley versus Vallejo, which said that, quote, the concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment, unquote. Now, this is an important point. I think it just has to be pointed out. Democrats' claims that Citizens United overruled 100 years of precedent are simply untrue. The 100 years claim points to the Tillman Act, passed in 1907, which barred contributions, namely given to candidates. Citizens United was about expenditures, money spent on independent advertising. The first federal law limiting corporate and labor union expenditures was not passed until 1947 and was not addressed by the Supreme Court until the 1970s. Plus, I pointed out there are at least 25 cases that were precedential that Citizens United basically backed. Now, to get to you, General Kagan, let me just say this. I also want to look briefly at another free speech case, and that's United States versus Stevens. The defendant argued that the federal statute prohibiting the sale of depictions of animal cruelty was unconstitutional. In your brief defending the statute, you made this argument, quote, whether a given category of speech enjoys First Amendment protection depends upon a categorical balancing of the value of the speech against its societal costs, unquote. Now, in his opinion for the court, Chief Justice Roberts responded to your theory this way, quote, "is a free-floating test for First Amendment coverage." That sentence, wherein you stated that whether a given category of speech enjoys First Amendment protection depends upon a categorical balancing of the value of the speech against its societal costs, unquote. He said that as a free-floating test, he said, for First Amendment coverage, that sentence is startling and dangerous, unquote. Now, I know you were representing your client, the United States, in this case, but you certainly did not have to make that unusual argument. Now, here's why I'm concerned about it. It sounds a lot like other subjective theories that give judges a lot of power that you have discussed in your law journal activities. Whether it is focusing on hidden subjective motives rather than actual objective effects, imposing restrictions based on the identity of the speaker, or here basing freedom of speech on an assessment of value and cost, I'm really troubled by how much power your arguments and theories appear to give to judges. Now, am I wrong to be concerned about this?
Senator Hatch, I think you are wrong to be concerned about it. Let me first talk about the United States versus Stevens brief. It's a hard case. Congress had passed a statute, and it was a statute designed to deal with horrific acts of animal cruelty, including these things that I didn't know existed, these crushed videos.
That none of us would like, that's for sure.
But it was a statute that I hesitate to criticize Congress's work, but it was a statute that was not drafted with the kind of precision that made it easy to defend from a First Amendment challenge. And we thought that our best argument, really our, the only argument that we had, was to analogize the statute to other categories of expressive activity that the court had held were simply not protected by the First Amendment. And most notably, the two categories that we used in that brief were obscenity and child pornography. And those are categories where I think the court has done this kind of categorical balancing that I spoke of, we spoke of in the brief, where the court has said, look, when it comes to obscenity or child pornography is an especially apt example because the harm that Congress was trying to get at here, what Congress was trying to do was to turn off the spigot of distribution so that these materials would not be made in the first place. And that was the theory that the court used to say that child pornography could be regulated under the First Amendment. That if we shut down the mechanisms of distributing and this material, nobody would produce this material. And that's what Congress, that was clearly Congress's focus in passing this animal cruelty statute. And so what we tried to do was to analogize this statute to the child pornography laws that the court had upheld in Ferber, and to say that the court should uphold this statute for the identical reason that it upheld the child pornography laws, that the court should realize the extraordinary harms of this speech and should realize the way in which this regulation was really aimed at stopping the initial production, the initial horrific acts that went into the production of this speech. And that was the government's view. It was a view that was accepted by Justice Alito in the case. He was the only vote we got, but he essentially accepted that theory. I think it was a very hard case because it was, again, I hesitate to criticize Congress's work, but another statute would have been easier to defend on First Amendment grounds, but we tried to do the best we could with it.
You and I agree on that. I still have just a couple of questions about the military recruiting issue. You said yesterday that, quote, the only thing that was at issue was essentially the sponsoring organizations, whether it was the Office of Career Services or instead the Student Veterans Organization, unquote. Now, it seems to me, though, that in addition to who sponsored the recruiters, the real question was what they were able to offer.
I'm sorry, what they were able?
what they were able to offer. The law, after all, says nothing about sponsors, and it says nothing about whether recruiting goes up or down in a particular time period. The law requires the same access to campus and students for the military as other employers receive. The Harvard Law School Veterans Association has said that they had a tiny membership, meager budget, and no office space. All they could do was facilitate a few student-initiated contacts with military recruiters. All they could do was establish an email account to receive inquiries from students. Now, is this what you referred to yesterday as, quote, full and complete access to our students, unquote? And did you believe that this was an equal substitute for what the Office of Career Services provided for all other employers, all other legal employers?
Senator Hatch, I did believe that it was an equally effective substitute, that what our Office of Career Services does, they do a good job, but what they do is basically no more than to ensure that students know when when an employer of any kind is coming, and to enable the student and the employer to hook up with each other. And that's what our Office of Career Services do. We have upwards of 700 or 800 employers that come to our campus every year, and what the Office of Career Services does is to make sure that students know when those 700 or 800 employers are coming and where they're going to be, and to make sure.
You have to admit that the facilities weren't as available to the military, to the recruiters, that they would have been with the office that you're describing. I mean, let me make that point a little bit more clear, maybe. Yesterday, you also said that the military, quote, the military at all times during my deanship had full and good access, unquote. Now, the Judge Advocate General's office, however, stated that without access to the Office of Career Services, quote, we are relegated to wandering the halls in hopes that someone will stop and talk to us. It is our view that denying access to the Career Services office is tantamount to chaining and locking the front door of the law school, as it has the same impact on our recruiting efforts, unquote. Again, I'm not asking whether recruiting went up or down, or whether there was some access to something at all time. The law requires the same access for the military as other employers, not access that the dean may consider good. Do you disagree with this description of the situation by the Office of the Judge Advocate General?
Senator Hatch, I appreciate that reasonable people can disagree about this issue. But I do think that the military at all times, regardless whether the Office of Career Services was sponsoring or the Veterans Association was sponsoring, had excellent access to our students. And over many years prior to my deanship, the Veterans Association had sponsored. The Department of Defense had thought that that sponsorship was fully adequate to their needs. And I think that there are other documents in those records which suggest that, which suggest the Department of Defense going in and saying, we met with a lot of people and it was great, and we very much appreciate the access that we were getting. The Office of Career Services really exists as a kind of, it makes sure that students know that employers are coming, and it makes sure that students have the opportunity to talk with those employers. The Veterans Association did a fabulous job of doing the same thing, and so I do think that the military recruiters had excellent access either way, and in fact, that semester in my deanship, the one period of 12 in which the Veterans Association did sponsor the interviews, in that year, military recruiting did go up, and I do think that the effects, in some sense, speak for themselves.
Okay. Well, let me switch topics again, this time to abortion. When Congress debated the ban on partial birth abortion, one issue was whether this particularly gruesome abortion method was medically necessary. The American College of Obstetricians and Gynecologists, or ACOG they call it, is a natural source of medical opinion on this subject. According to the documents we received, you wrote a memo to your superiors in the Clinton White House about this, you noted that the American College of Obstetricians and Gynecologists was considering a statement that its experts panel found no circumstances under which partial birth abortion was the only option for saving the life or preserving the health of the woman. You wrote, quote, "This, of course, would be disaster," unquote. That's something that does bother me, because it would be a disaster, you wrote, because ACOG opposed the ban on partial birth abortion. If anyone ever found out, and you wrote that it could leak, even if ACOG did not officially release its original statement, it could have negative political consequences. So you drafted alternative language that would say that partial birth abortion, quote, "may be the best or most appropriate procedure in a particular circumstance to save the life or preserve the health of the woman," unquote. Now that's a very different spin, and obviously a more politically useful spin. The ACOG Executive Board copied your language verbatim into its final statement. Your language played an enormous role in both legal and political fights over banning partial birth abortion. The Supreme Court relied on it when striking down the Nebraska ban in Stenhart v. Carhart. Now, I'm really stunned by what appears to be a real politicization of science. The political objective of keeping partial birth abortion legal appears to have trumped what a medical organization originally wrote and left to its own scientific inquiry, and that they had concluded. Did you write that memo?
Senator, with respect, I don't think that that's what happened here.
I'm happy to have you clarify it. That's my question. Did you write that memo?
I'm sorry, the memo which is?
The memo that basically caused them to go back to the language of medically necessary. That was the big issue to begin with.
Yes, well, I've seen the document, and the document
but did you write it? Is that your memo?
The document is certainly in my handwriting. I don't know whether the document was a product of a conversation that I had had with them. If I could just go back, Senator Hatch.
Okay.
This was an incredibly difficult issue for everybody who was associated with it for obvious reasons. The President Clinton had strong views on this issue, and what he thought was that this procedure should be banned in all cases except where the procedure was necessary to save the life or to prevent serious health consequences to the woman. And those were always his principles. And we tried over the course of the period of time when this statute was being considered, actually twice, to get him absolutely the best medical evidence on this subject possible. And it was not easy because, as everybody in Congress knows, different people said different things about this. There was conflicting evidence. And we tried to do our best to bring all the evidence, all the conflicting views to his attention. In the course of that, we did indeed speak with ACOG. ACOG had an interest in this statute, and ACOG had views about this statute. What ACOG thought and always conveyed to us was two things. What ACOG thought was that on the one hand, they couldn't think of a circumstance in which this procedure was the absolutely only procedure that could be used in a given case. But second, on the other hand, that they could think of circumstances in which it was the medically best or medically most appropriate procedure, that it was the procedure with the least risk attached to it in terms of preventing the harm to the women's health. And so we knew that ACOG thought both of these things. We informed the President, President Clinton, of that fact. There did come a time when we saw a draft statement that stated the first of these things, which we knew ACOG to believe, but not the second, which we also knew ACOG to believe. And I had some discussions with ACOG about that draft.
My time is about up. Let me just ask that question again. Did you write, quote, "This, of course, would be a disaster," unquote? Handwriting. You didn't get that from the
No, you're exactly right. I'm sorry, I didn't realize you were referring.
That's what I wanted to know.
Yes, no, that's exactly right. And the disaster would be if the statement did not accurately reflect all of what ACOG thought. Both, I mean, that there were two parts of what ACOG thought. And I recall generally, not with any great specificity, but recall generally talking to ACOG about that statement and about whether that statement was consistent with the views that we knew it had because they had stated them, that there was both not the only procedure, but also that it was in some circumstances the medically best procedure. And in their final statement, that sentence that it was not the only procedure, of course, remained because that is what they thought. But we did have some discussions about clarifying the second aspect of what they also thought, which was that it was in some circumstances the medically most appropriate procedure. And so I think that this was all done in order to present both to the President and to Congress the most accurate understanding of what this important organization of doctors believed with respect to this issue.
Mr. Chairman, I just have one or two sentences I'd like to say, and then I'll finish.
I'll give you extra time.
Thank you, Mr. Chairman. Well, I'll tell you, this bothers me a lot because I know that there were plenty of doctors in ACOG who did not believe that partial birth abortion was an essential procedure and who believed that it was really a brutal procedure. And it was a constant conflict there. And as you know, many in Congress came to the conclusion it was a brutal procedure, too, that really was unjustified. That bothers me that you intervened in that particular area in that way. Well, that's all I'll say about it, but I just wanted you to be aware that that bothers me.
Senator Hatch, there was no way in which I would have or could have intervened with ACOG, which is a respected body of physicians, to get it to change its medical views on the question. The only question that we were talking about was whether this statement that they were going to issue accurately reflected the views that they had expressed to the President's staff, to Congress, and to the American public. I do agree with you. This was an enormously hard issue. And President Clinton found it so and thought that the procedure should not be used except in cases where it was necessary for life or health purposes. And we tried to get him the best information we could about the medical need for this procedure, something that was not always easy, and tried to, in all the statements that he made, to make sure, and any statements, other statements that we were aware of, to make sure that that information was accurately conveyed to the American public.
Among one of the things I did as an attorney was represent doctors, including some obstetrician and gynecologists, and I had a lot of experience with them. I hardly ever met anybody who thought that was a fair or good procedure. But be that as it may, I just want you to know I'm troubled by it, and even though I care a great deal for you and respect you.